it is not necessary for the couple to wait for 6 months and reduce the 6 months time to 1 week if the couple already spent the 6 months of separation prior to filing the joint application. I'm Prasad. I'm an advocate practicing in Hyderabad. Today I'm going to share with you answers to the questions pertaining to the topic mutual consent divorce. I have listed out all the questions in the description box with the timeline. Select the question of your interest and directly jump to the question if you don't have time to listen to the entire video. Generally, there are two types of divorces. One is the contested divorce, where the husband seeks for divorce. Generally, husband seeks for divorce and the wife opposes it, or else wife seeks for divorce and husband opposes it. So that is a contested divorce. And there is other divorce called, from the 1976 amendment, there is another divorce called mutual consent divorce. So mutual consent divorce is compromise between husband and wife to obtain divorce. There is no dispute when they come to court. They settle all the disputes out of the court and they come to the court and obtain the divorce. So that is called the mutual consent divorce. There are 3 periods that are involved in this mutual consent divorce. The one is 1 year of separation prior to filing a joint application before the family court. That is the first timeline. The second timeline is the 6 months cooling period. Once you file a joint application before the family court will ask you to wait for 6 months. Court will try for settlement. Court will see whether you took the decision in haste or not. So the second timeline is 6 months. And the third timeline is after completing the 6 months and within 1 year after completing the 6 months, you have to approach, both the husband and wife have to jointly approach the court and inform the court that all the efforts for settlement failed and they are ready for divorce. So it is basically 1 year, 6 months and another 1 year. There are only 2 steps. You come to court with a Memorandum of Understanding which includes all the settlement terms. Settlement terms are basically of 3 types. One is child custody. The second is property management, immobile, movable, marriage expenses, gold, etc. The third is maintenance, clause pertaining to alimony and maintenance. There are only 2 steps. You file a joint application, wait for 6 months, again come to the court and then inform the court that the efforts pertaining to the settlement failed and then you seek divorce, mutual consent divorce. Imagine the marriage occurred in Tirupati and they last resided in Delhi, but the husband belongs to Mumbai and the wife hails from Calcutta. In the instant example, there are 4 places that are coming up. The place of marriage, you can file a divorce application. The couple last resided, divorce application will be filed. In the 1 year separation period, the husband stayed at Mumbai and the wife stayed at Calcutta. So you can file a divorce application in Mumbai and also Calcutta. So the 4 places come for the jurisdiction of the family court where you can file the divorce application. The husband and wife must compulsorily appear before the family court to file the divorce application and also while taking the divorce, and that is in the second motion also. During the second motion also, husband and wife has to appear. That is mandatory along with their counsel if they appoint any counsel. MOU is necessary. Property documents pertaining to the transfer of property and child custody, alimony, property matters, everything will be covered in MOU. So there is nothing fresh coming up in the MOU. So MOU document is necessary. Real estate documents are necessary. Identification is necessary. The proof for 1 year separation is necessary. Income tax certificates of the husband and wife are necessary because court even checks whether there is a balance in the MOU or not. That is also important. But marriage certificate, registered marriage certificate, if at all it is registered. So Memorandum of Understanding will have 3 main ingredients. The ingredient pertaining to the child custody, property, sharing of the property, and the third is alimony or the maintenance. Court expenses are very much economical and reasonable, and which are less than 500 rupees, I could say. Yes, alimony and child custody are settled in the Memorandum of Understanding, which is mandatory while taking a mutual consent divorce decree. This is the only dispute that is available between husband and wife. Yes, in Amardeep Singh case, Supreme Court clarified that power of attorney can be given to family members, that is the parents of the spouse or any siblings or of the spouse. If they are not available to take the divorce decree, they can give power of attorney to the parents, and based on that, divorce decree can be granted, is what was settled by the Honorable Supreme Court in Amardeep Singh case. That was clarified. Can live together, the couple can marry together, but the consent decree cannot be dissolved because it is a consent decree, it is a compromise decree, and there is nothing that can be done with the compromise decree. They are fresh individuals and they can start their life afresh after taking the divorce decree from the court. They can anyhow marry again through the marriage law, and they can start their life afresh, or they can live together without marriage also. That is also not an issue. But divorce decree can't be cancelled. Proceedings through video conference was also taken care of in Amardeep Singh's case by the Honorable Supreme Court. The couple can participate through the video conference. If they are not residing in India, or if they are not residing at the family court, they can participate through video conference, but that will be subject to proper identification. The couple can marry anytime. The husband or the wife, once the divorce decree is granted, they can marry the next day also. Unlike in a contested divorce, they have to wait for 3 months, because the husband or the wife who lost the case has every chance to go for appeal. So the appeal time is 3 months. So therefore they have to wait for 3 months in a contested case, but they don't need to wait for any amount of time when it is a mutual consent divorce decree. Same house. Yes, this is living together. The expression living together was explained in Sureshta Devi case, where Supreme Court clarified that they must not perform any marital obligations. They can live under the same roof and they can apply for mutual consent divorce decree. That was clarified in way back in 1991 itself. The amendment came in 1976, but Supreme Court clarified this matter in 1991 itself. Now, what does it mean that not performing marital obligations? That is, they must not have any sex between the husband and wife. They should not satisfy any physical needs. Maintenance claim cannot be made again by the wife after obtaining mutual consent divorce decree, because that aspect is already covered in the MOU. In India, online application for mutual consent divorce is not yet ready. The courts are not yet ready for filing online application. The couple cannot participate in extramarital affair, or the couple cannot participate in the sex outside the marriage in the 6 months cooling period or during the time of separation, because any time the very purpose of 6 months cooling period is to attempt settlement by the court. So during the settlement, if the couple resorts to this kind of activities, then there is every chance that mutual consent divorce decree will not be granted. Yes, marriage expenses can be claimed in the mutual consent divorce decree through the MOU. In the MOU, the clause pertaining to marriage expenses can be inserted in the Memorandum of Understanding. Yes, it can be transferred from one state to another state by filing an application in Honorable Supreme Court. Three elements: child custody, alimony, and property issues must be settled. The property issues include immovable property, movable property, marriage expenses, gold. All these aspects must be settled pertaining to the money matter must be settled, the alimony matter must be settled, that is the maintenance matter must be settled, child custody must be settled. These three elements form important components of MOU between the husband and wife, and that must be filed in the court. If they are married under Special Marriage Act, then also this concept of mutual consent divorce can be attempted. Though parents are not necessary to be present while obtaining this mutual consent divorce decree. There will be two motions. The motions means there will be two dates 2 adjournments. That's the minimum. So based on these 2 adjournments, the second adjournment can be preponed from 6 months to 1 week. This was clarified in Amardeep Singh's case. That can be done only when the couple completed 18 months prior to approaching the court and moving the first application and moving the joint application. It can be done as per the Amardeep Singh's case. Then 1 week is the time. What are the elements for preponing this thing is 18 months must be completed before filing the joint application. The MOU must be completed and the terms of the MOU must be performed. That is to say, the terms pertaining to alimony, the terms pertaining to child custody, the terms pertaining to property settlement, mobile, immobile, gold, marriage expenses, etc. Everything must be completed prior to filing the MOU. That is important because without completing all these terms, court will be of the view that there is still scope for settlement. So another important ingredient is court must come to a conclusion that all the settlement efforts pertaining to the couple through the civil procedure code and through the family courts and through the Hindu Marriage Act must fail in order to go for consent decree. Decree, you can't file any defamation case pertaining to the cases already filed prior to initiating the mutual consent divorce decree proceedings through the 498A or dowry harassment or domestic violence. There could be an instance where you could have attempted mutual consent divorce based on the 498A case or the domestic violence case, because all pending cases must be closed through this mutual consent divorce decree proceedings. That is mandatory. No case must be pending. If cases are pending, what is the purpose of mutual consent divorce? So parties have to settle peacefully. That is the aim and object of the mutual consent divorce concept. A couple has to come before the judge for 2 times. Once while filing the joint application and after 6 months, informing the court that there is no settlement between the couple. If fraud or force or undue influence is exercised on wife, generally it is on the wife that is done, then the wife can inform the court while filing the joint application or even while coming for the second time. After 6 months, wife can inform the court that this is being done only by force or fraud or undue influence. Then in such kind of circumstances, divorce decree will not be granted. No, mutual consent divorce decree cannot be obtained by the notary. If you attempt such kind of steps, it is illegal. NRIs can get mutual consent divorce decree as already informed through the power of attorney or through the video conference, which is already clarified by the Honorable Supreme Court in Amardeep Singh's case. Okay, thank you. Thanks for watching. Bye-bye.